So the accused herein, David Bogonko Nyokang'i, faces 2 counts of the offenses of publication of false information under section 23, 231, I believe, of the 23 of the Computer Misuse and Cybercrimes Act 2018. The particulars of the respective charges are succinctly set out on the face of the charge sheet. I'll not regurgitate the same. The accused person denied the charges and the matter proceeded to trial. The prosecution called a total of 3 witnesses. At the commencement of the trial, the accused person was unrepresented, but was later on represented by the learned counsel, Mr. Omari, when the 3rd witness on behalf of the prosecution testified. So when the matter came up for hearing on the 15th day of December this year, 2025, the learned prosecutor, Mr. Omari, closed the prosecution case prematurely with the indication that he had not received the police file and the investigating officer was unreachable. At this stage, the matter is coming up for a determination whether the prosecution has established a prima facie case against the accused person and consequently whether the accused person should be placed on his defense. So I've cited the 3 case law. I'll not go into it. I've cited the case of Republic versus Abdi Ibrahim, criminal case number 6 of 2011, on the good law on what a prima facie case is. I've also cited the obvious case of Ramnal Bat versus Republic, 1957, the East Africa 332. I'll not go into it. I've also cited the case of Ronald Nyaga Kuria versus Republic, criminal revision number 124 of 2018. I'll equally not go into it. So the brief background of this matter is that PW1, Dr. Bessie Akinyi Byakika, and PW2, Professor Timothy Kagoda Byakika, both distinguished medical practitioners, testified that on or about the 26th of June 2024, it was brought to their attention of 2 publications that were made in kenyaleo.co.ke that made reference to them. They indicated that the publications were published on the 26th of June 2024 and another one on the 1st of June 2024. The same were marked for identification as Prosecution MFI 1 and 2 respectively. They asseverated that both publications were false and defamatory. They decried that the said publication had caused profound anguish and despair and had also affected their marriage, medical practice, and standing in the society. It was their testimony that it was the accused person who was the owner of the said domain. PW2, that is Professor Timothy Byakika, stated that following his investigation, it was established that the source of the publication was the accused person. PW number 3, that is Inspector Ezra Koech, a digital forensic analyst, testified on the 6th of July 2024. They received a request from the DCI, Nairobi region, to provide information in respect to the domain kenyaleo.co.ke. He avowed that they were able to retrieve the articles that was edited and published by one Sharif Juma on the 1st of June 2024, and the other one by Nelson Washira on the 26th of June 2024. During cross-examination by the learned counsel, Mr. Omari, he indicated that the publications were online posts. He also averred that he only got to know the registrar of the domain, which he pointed out was TrueHost Cloud Limited. He stated that his role ended at the point of identifying the domain, giving details of the registrar of the said domain, and also retrieving of the articles or publications. He elucidated that Kenya Network Information Center, KENIC, was the government agency that licenses and regulates such domains. He urged that it is only the owner of the domain who can give details of the user, and that it's only the administrator who can give details of the logs, of the said logs. The Nane Counsel, Mr. Omari, made brief and very concise erudite oral submissions at the close of the prosecution case, urging that the prosecution has not established a prima facie case. I have considered the same. So as pointed out herein above, the prosecution case was closed prematurely. Also, as indicated, only 3 witnesses testified. Those are the 2 complainants and the digital forensic analyst. The investigating officer, amongst other witnesses, did not testify. From the testimony of the digital forensic analyst, that is PW1, Inspector of Police Ezra Koech, it is pellucid that the publication cannot be attributed with exactitude to the accused person. In his cyber investigation report, which was produced as prosecution exhibit number 4, which is the only exhibit that was produced in this matter, does not make reference to the accused person as the publisher, editor, or the registrar having control of that domain that publish the impugned articles. Moreover, the said publication was only marked for identification and was not produced as exhibits. Flowing from the foregoing, it is ineluctable that the prosecution has failed to establish a prima facie case to warrant the accused person to be placed on his defense. Consequently, I hereby acquit the accused person pursuant to section 210 of the Criminal Procedure Code. The cash bill will be refunded to the depositor.
Much obliged. Thank you very much. We appreciate it. Then I'm going to please have the list that the subject process.
After included. Karibu sana Mr. Ombele. Good morning.
Sorry, I'm late. I was there.
Okay.
Tied up in another one.
Yeah, you came out as we were just winding up.
Yes.
But I'm sure he'll give you a recap
Yes,
of the same.
you will do so.
Okay, thank you. So the cash bill to be refunded.